Morning. Good morning, everybody. Welcome to the First District Court of Appeals. As you might have noticed, Judge Myers is unavailable to be with us this morning, but she will be watching the arguments on YouTube and participating in the decision. So we have one case to be argued this morning, which is State v. Rawls. Ms. Giese, or you may go ahead and proceed. And how much time would you like for rebuttal?
I'd like three minutes, please.
3 minutes. Okay, very well.
Good morning. May it please the court. Mr. Cummings. The crux of this case is that the trial court wrongly applied the burdens regarding the new self-defense law, and that the record supports that Mr. Rawls did indeed act in self-defense when he fired a single shot at Mr. Bibbs. Now, I don't want to spend a lot of time going over the law. You guys know it. With the version in effect at the time, there were still 3 prongs to the deadly self-defense case. The trial court rightly found that Mr. Rawls fulfilled his initial burden of production, that the burden shifted, but then the trial court wrongly applied the standard for the burden of persuasion in assessing whether the state met its burden to disprove self-defense beyond a reasonable doubt.
And I guess I'm a little bit confused on that because the court used the term beyond a reasonable doubt as it was assessing the evidence. So where in the record do you see the misapplication?
Sure, Judge. So the trial court, and our argument is that the trial court did in fact state the standard correctly, but then didn't apply it correctly. And there are actually 2 things the trial court respectfully did wrong. When you read the trial court's findings, so the trial court went through and found that the 2 men had a damaged relationship over the debt, that Mr. Bibbs approached Mr. Rawls as soon as he got out of the car. They had a loud verbal exchange, that Mr. Bibbs had a propensity and reputation for violence, he was larger, etc. And then cited a finding that Mr. Rawls did not provide corroboration for any of the alleged threats to reach a finding that the objective reasonable fear prong was not met. So in going through that assessment and then citing the alleged omissions in the record, the court placed the burden of persuasion back on Mr. Rawls. So if this was done correctly, the court's analysis should have read, the state failed to disprove XYZ beyond a reasonable doubt, not Mr. Rawls failed to prove XYZ beyond a reasonable doubt. And that's where the court, even though it said the standard right, applied it wrong. The second prong of that, not only shifting the burden of production and persuasion onto Mr. Rawls, that was the first thing the trial court did wrong. The second thing the court did wrong is it construed the evidence in favor of the state then when it went back to construe the state's burden. And under this court's Parrish opinion recognized it, citing the seminal case, I think it's Melchior out of the Ohio Supreme Court. The burden of production, you do rightly construe the facts in favor of the proponent of self-defense. It's akin to sufficiency review. Then when the burden shifts to the burden of persuasion, you no longer, it's more akin to manifest weight review. There's a burden of persuasion. There is a credibility component inherent to that. So the law, even though I could not find a case directly on point assessing this narrow issue, it stands to reason that you don't then construe the facts in favor of the state when you go to assess its burden of persuasion. And that's what the court, again, in citing the omissions in the record, that's what the court effectively did. So the court's analysis and application of self-defense was wrong on both fronts. And that's really just the first assignment of error is more procedural. We would argue that that level, rises to reversible error and requires reversal in a new trial. Getting to the second assignment of error, which is the actual weight of the evidence.
Ma'am, let me just stop you.
Sure.
About this self-defense.
Yes.
And this has been bedeviling trial courts and courts of appeals ever since the legislature changed the law. And this is my question. The statute uses the term that there's evidence presented that tends to support the accused person use force in self-defense. And at that point, then, it looks like it's the prosecution burden to prove beyond a reasonable doubt that self-defense was not appropriate. My question is, how far does one hit? What does tends to support? Does that mean if you prove one prong or two prongs, or do you have to prove all four before the burden shifts?
Again, it's more under the Melchior. It is akin to a sufficiency, but tends to prove it's even lower than preponderance. I think that courts, before the statute changed, even used to attribute a preponderance standard, and the tends to prove arguably is even lower. It just produces some. On sufficiency review, a motion for acquittal, you do construe the evidence and all the allegations in favor. Then you say, is there something to each prong? And it's very low.
All right. So, but it has to be with regard to each prong.
Yes.
Okay. Because if the court believed that this fellow was running at him, saying you're dead, just those. All right. Is that enough to shift it to the prosecution?
Right.
You think it is?
I do, yes.
Okay. Right.
Yes, again, it's sufficiency. Think of when the trial courts assess a motion for acquittal after the state rests. It is a very low burden. There's something that goes to, usually it's by cross-examination at that point, that goes to each element. And so here, the court properly found there was evidence adduced that went to at least each element, enough to shift the burden. And then the analysis changes when you assess, in part due to the high burden on the state. It becomes from less than a preponderance on the burden of production to beyond a reasonable doubt on the burden of persuasion, that it's disproved. So it has been perplexing, and I think these fine nuances maybe have not even been fleshed out by the Ohio Supreme Court, but it's our position that the law cited in our brief supports this interpretation. If there are more questions on the first assignment of error, I'll just move to the second. Okay. The standard of review, that is also a novel argument that I'm advancing in truth for the Columbus 7, who I hope not to need. But that is really just a novel, because it's an objective assessment, really the credibility of the evidence doesn't come into play as much. And I don't want to spend a whole lot of time on that. Really, if you go to the meat of the argument, the credibility of the evidence, we respectfully submit that the weight supports that both prongs that the trial court found lacking, that Mr. Rawls' the objective fear was met and the duty to retreat was not feasible. And as far as the, again, if you construe the evidence in favor of the proponent on the burden of persuasion, the same would hold that the evidence that, it's imperative that the panel put themselves in that position as a reasonable person, that like we all are. 2 police officers testified to support that Mr. Bibbs had a reputation for violence. Mr. Rawls testified that he had seen Mr. Bibbs commit acts of violence against other people, and that his nickname, Flip, was given because he easily shifted mentality, they flipped out. Mr. Rawls knew Mr. Bibbs to carry a weapon. Mr. Bibbs was 4 inches taller, 50 pounds heavier at the time. He probably had a longer reach. Usually taller people have a longer reach, so if Mr. Rawls, a much smaller man, tried to turn and run, could have been tackled, could have been stabbed or shot in the back. And then, Mr. Bibbs did confront Mr. Rawls in the dead of night, unexpected, ran up to him, said, "You're dead." They had been fighting, threatening for 2 weeks. He had been threatened by this man. And the most important factor, that Dr. Nelson, who is a highly credentialed expert, testified that Mr. Bibbs was on this Superman amount of methamphetamine.
Well, but I guess I don't understand that part of it, because that only matters if your client knew that he was under the influence, right? I mean, because unless there was some objective manifestation of being under the influence, because otherwise I'm not sure how it would implicate self-defense.
Right, and I think that was defense counsel's point in eliciting this testimony via deposition, is that anyone on such a high amount of meth exhibits these certain characteristics. As Dr. Nelson said, it doesn't happen in some people and not others. It is akin to, let's say in OVI cases, they say that indicia of intoxication, even the layperson can tell when someone is extremely inebriated, slurring, stumbling, red eyes, whatever. So by analogy, or in the same way, Dr. Nelson is saying when someone is on this, and I forget the numbers, but this amount of meth, they are aggressive, they're hyped up. It's the opposite of heroin. Their systems are amped up, their heart rate is raised. Someone under this amount usually will be aggressive, irrational, come up, you're dead. And that's what the defense was trying to convey, even though these people weren't there to see it. Just like when we know when someone is extremely drunk, how they act. So it does inform the objective inquiry. Given these circumstances, we would argue that any person, any one of us, any person faced with that, really even maybe milliseconds to react. Like I said in my brief, and not to be facetious, but this is not the movies. You can't just cleanly turn around and, hey, point your gun, I'm going to walk away now. You have to react in that moment. And he did. And Mr. Rawls' action was not disproportionate, which is part of the analysis. He fired one shot from a very small caliber gun. Very unfortunate that it found its way to an organ and caused death. Any gun can cause death. But he just fired one shot from that little one and left.
Well, but I mean, and I guess this might go to your imperfect self-defense, but there is the threat of you're dead, but there is no manifestation of a weapon or anything beyond that. And to fire when it appears that the guy doesn't have a weapon does seem to be overly dramatic under those circumstances.
Well, and again, Mr. Rawls knew they before this debt, they were friends. He knew his friend to carry a weapon at times. He couldn't tell in that moment. It was dark. It was midnight. It was sudden. He didn't know if his friend was carrying or not. It was safe to he presumed that he would be. And again, this is all instantaneous. This is microseconds. And look at all the circumstances surrounding it. It was, he did the one thing. And there was a case we cited in our brief that a person does not have to wait to get beat to exercise self-defense. And we would argue that compels the conclusion that he took the reasonable step based upon all the circumstances that faced him. I see that my time for direct is wrapped up, so I will preserve the rest of the time for rebuttal.
Okay, very well. Thank you. Mr. Cummings?
Yes, good morning.
Morning.
I guess I will respond to the appellant's claims in order that they were presented. As far as the burden of persuasion being shifted, when the court discusses there being no corroboration of Mr. Rawls' claim, I really think that is not a shifting burden as much as the judge is addressing credibility. And in her mind, she did not believe Rawls when he was making these claims that he feared for his life and he was an imminent threat. I think that this court, I think each of you judges were on the case, Vandergriff, I believe, last year, which discussed the light in which you view the evidence. And I think that the state has to disprove the elements of self-defense. When you evaluate whether or not the state successfully did that, as this court noted in Vandergriff, you have to view the light and you have to view the evidence in a light most favorable to the state. Could any rational trier of fact have found that the defendant did not act in self-defense here? And I think the answer here is clear that certainly they could find that he did not act in self-defense. The state disproved both elements that the judge referenced. Again, this is a bench trial where the judge is presumed to have known the law and applied it appropriately. I think the record reflects she took this very seriously, deliberated about it, considered it very thoroughly, and I think there's no indication that she misapplied the law or went astray.
But what about the duty to retreat? Because that's what gets a lot of emphasis in the appellant's brief. I'm just trying to get my arms around how that should be applied in a situation like this, because there is the logical extension of the reasoning would be like there's always the ability to retreat unless you're like stuck in a house and you're locked in or something. And I mean, the hypotheticals of you could have run, you could have, brandished your weapon, you could have taken measures. Like, doesn't that always come into play in self-defense?
Oh, absolutely, it does. Yes, I think here the state did elicit testimony from the doctor that there was a distance between the two when he fired. It's not as though the victim was right on top of him. I think Mr. Gibson also testified that he saw the defendant take a step back and actually put his hand out to create this distance, and he didn't step back. This goes to the fact that there was space, I guess. There was areas around him. It also goes to the fact that he's armed, that the victim is not. So I think he could have done other things than what he did, which he chose to fire. And I think the unfortunate tale of this case is really found in Mr. Barwick's comment, I think on page 126 or 160. In that testimony, he says that the defendant told him, if this victim ever comes up to me, if Biggs ever comes up to me, I'm just going to shoot him. And this reminds me of something I learned as a child, that what you envision is what you experience. And I think what Mr. Barwick was saying is that this defendant, in his mind, had gone over and over what he was going to do if he was ever confronted with Mr. Biggs. And I don't think he was provoked in the moment to use self-defense. He was executing something that he had played out in his mind over and over and over again. This was premeditated in that sense, and I think really that's the tale of what's going on here. But I think that clearly the trial court applied the law appropriately, and I don't think that there's any indication that she clearly made an error here. I would say that this evidence about the defendant being high and being on whatever he was on to make him violent, if you look at the record, for a violent man who was high, he didn't manifest that. The witnesses that saw this event said that he did not run up to the defendant. He did not hit him. He did not try to punch him. He didn't try to shoot him. He walked up briskly and said, "Hey, what's up?" And that is not the conduct of somebody that's high and out of their mind. So I think this is all kind of a red herring when it comes to.
Well, I mean, there seems to be a factual dispute on exactly what he said, because I think the defendant indicated that it was the "you're dead" comment, but the person in the car testified that it was a more innocuous comment.
Right. Yeah. There's a spectrum here of what the witnesses testified to. Some testified to it being almost very calm and conversational, and some others say, yeah, it was tense. There was some interaction here that was tense. But I think the bottom line, when you read this record, you come away with the fact that the trial court weighed the evidence appropriately and came to the right decision, really. And unless this court has any specific questions, I'll leave it at that.
Yeah.
Okay, thank you.
No, thank you.
All right. Thank you for your argument.
Just a couple of quick cleanup points. If I heard Mr. Cummings right, regarding the burden of persuasion, we would just respectfully disagree that the law does not countenance construing the evidence in a light favorable to the state when assessing burden of persuasion. Burden of persuasion is higher than burden of production. Here, it's to the extent of beyond a reasonable doubt. And again, burden of
Let me just, going back to the question I was asking Mr. Cummings, there is a history here, there is tension here between these two individuals, and assuming that the victim said, "you're dead," like there is a threat embedded in that. Does that threat, does a verbal threat without any physical manifestation or a weapon being present, under Ohio law, justify someone in shooting that person in self-defense? Because I worry about the ramifications of that, just, I don't know, that's one of the things I'm struggling with.
Sure. So I would say that to answer that question, you cannot look at the one factor in a vacuum. Someone could be shouting, "you're dead," across a football field, and of course that's not going to be enough to warrant deadly force. You have to place it back in context of that night and being in close proximity. Mr. Bibbs likely exhibiting those frightening demeanor, the loud verbal exchange, and that's one thing I wanted to answer, that the witnesses were kind of all over the place on the confrontation, but all of the witnesses, both Mr. Rawls' witness and the state's witnesses, said they weren't really paying attention or they couldn't hear. The closest person, I think, approximately was Mr. Bentley, who said he was scrolling his phone, he wasn't really listening, but he did say loud verbal exchange, and it was all really quick. So if you look back at, you have to go back to the context. You have to go back. Even though it's an objective inquiry, it still is fact-specific every time. And we would submit that yes, you don't want to give free rein to that inquiry without more. But this case does present more. One more point, with Mr. Cummings respectfully said that the trial court, Mr. Rawls had, well, I think it was Mr. Gibson testified, he said, if he comes at me, I'm going to shoot him. For one, the trial court didn't even cite that. Two, he had been robbed at some point, so he carries now. And I don't think it was Mr. Bibbs specific. I don't think the trial court didn't even find that was some kind of premeditation. He was acquitted of purposeful murder. So I don't think that should be given much weight. Unless there are any further questions, we would just ask that this court reverse and remand for a new trial.
Okay.
Thank you.
Thank you.
Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written opinion. That concludes arguments this morning. We hope you both have a great day.